Assalamualaikum warahmatullahi wabarakatuh. My name is Ali Firdausa. I'm a law student from Universitas Internasional Batam. Today, I want to talk about private international law as a project individual project assignment given by Miss Rina and Miss Rahmi. Okay, first, we must understand what is private international law. A private international law is an independent legal field, not part of the civil code. Private international law is equivalent to the law of disputes and is better understood as part of law of dispute. Private international law is basically part of a country's national law and is not part of public international law, which means private international law is one of the subfields of law in a national legal system which together with other subfields of law such as civil law, commercial law, criminal law, etc. form a complete national legal system. The legal system of a country should be complemented by a national private international law system that is sourced from national legal source, but which is specifically developed to give the legal system the ability to resolve cases that contain foreign elements. According to Professor Grafferson, conflict of law or international private law is the field of law relating to cases which contain relevant facts that indicate connection with another legal system, but due to territorial aspect and aspect of the legal subject, and therefore raise question about the application of the law itself of the law others, which are usually foreign, or problem with the exercise of the jurisdiction of the court of the foreign court. According to Professor van Brakel, international civil law or private international law is a national law made for international legal relations. And other Professor Sudargo Gautomo, private international law are all regulation and legal decision that indicate which legal system applies or what constitutes law, if the relationship or even between citizens at a certain time show a point a connection with the system and legal norm of the two or more countries which differ in the environment of law, place, person, and matter. Next is the conclusion. Private international law is a set of rules, principles of rule of national law that are made to regulate even or legal relationship that contain transnational element or extraterritorial element. Private international issue basically arise in case involving more than one goal jurisdiction and the internal law of those jurisdictions differ from one another. Okay, next, from what I have learned so far from Miss Rina and Miss Rahmi, in this international private law, we are taught about how to solve problems by parties from different countries. From what I know of this private international law has two subjects. First, family matter between individual and individual, and second, business matter between corporation and corporation. There are steps that must be taken in resolving international private law. From what I learned, the first is we must know the chronology of the case. Secondly, we must know what issue or problem are being discussed. Then we make a characterization. In characterization, in family matter, we have like lex patriae, lex domicili, lex loci celebrationis, and etc. In business matter, we have lex patriae, lex domicili, lex loci solutionis, lex actus, lex loci damni, lex loci contractus, and etc. Then, the connecting factor to determine the law material from the problem, and the last is waiting for a decision. Well, next I will discuss about a little more about private international law. Introduction. The term of private international law is adopted by the civil law country, the Netherlands, Indonesia, but conflict of law is adopted by the common law country like USA, Australia, and UK. The meaning of private international law, conflict of law, or private international law, or international private law, branch of international law and interstate law that regulate a lawsuit involving a foreign element, where a difference in result will occur depending on which law are applied as the lex causa. The aspect of private international law: first, the jurisdiction of forum; second, the competing state law; third, the enforcement of foreign judgment. State. The meaning of state. A state is a set of institutions that possess that authority to make the rule that govern the people in one or more society, having internal and external sovereignty over a definite territory. The state includes such institutions as the armed force, civil service, or state bureaucracy, court, and police. The meaning of country, nation, and state. In casual usage, the term country, nation, and state are often used as if they were synonymous, but in a more strict usage they are distinguished. Country is the geographical area. Nation designates a people, however national and international, but consequently refer as well to matters pertaining to what are strictly state, as in national capital international law. State refer to state of governing institution with sovereignty over a definite territory. Choice of law. Court faced with a choice of law issue have a two-stage process. The court will apply the law of the forum lex fori to all procedural matters, including self-evidently the choice of law rule. And second, the court count the factor that connect or link the legal issue to the law of potentially relevant state and apply the law that have a direct connection. The law of nationality lex patriae or domicili or lex domicili will define legal status and capacity. The law of the state in which land is situated lex situs will be applied to determine all question of title. The law of the place where a transaction physically takes place or the will often be the controlling law select when the matter is substantive, but the proper law has become a more common choice. The status of foreign element. When the court to apply a foreign element, it must be proved by foreign law expert. It cannot merely be pleaded, as the court has no expertise in the law of foreign country, nor in how they might be applied in a foreign court. Such foreign law may be considered no more than evidence rather than law because of the issue of sovereignty. To apply one national legal system as against another may never be an entirely satisfactory approach. The party interest may always be better protected by applying a law concerned with international realities in mind. Okay, this is incidental question. For an incidental question to arise, the foreign court must have applied its characterization rule to determine that the main cause of action is governed by a foreign law. As a precondition to the main cause of action, there is a subsidiary question which has its own choice of law rule, pointing to a different lex causa. There will be a different result depending on which foreign law is applied. Incidental question. An incidental question is a legal issue that arises in connection with the major cause of action in a lawsuit. The foreign court will have already decided that it has jurisdiction to hear the case, resolving any issue relating to foreign shopping, and will be working to the next two stages of the conflict process, namely characterization and choice of law. The process. Why about the process? The court is required to analyze the pleading prepared by the party and to assign each component element to the most appropriate juridical concept of category. The rules of any given system of law are arranged under different categories, addressing procedure, status, contract, tort, divorce, nullity, and etc. For each category, there is one or more choice of law rules. The procedure for conflict case. The court must first decide whether it has the jurisdiction to hear the case, which will involve addressing the question of whether the plaintiff is attempting to manipulate the judicial system by forum shopping. Characterization. The court must analyze the case as pleaded and allocate each component to its appropriate legal classification, each of which will have no more choice of law rule attached to it. The court will then apply the choice of law rule in a limited number in cases usually involving family law issue. An incidental question can arise which will complicate this process. Renvoi. Renvoi is from the French, meaning sandbag. Is a subset of the choice of law rule, and it's potentially to be applied whenever a foreign court is directed to consider the law of another state. The application of renvoi. Because the doctrine is considered difficult and its results are sometimes unpredictable, its application has generally been limited to the validity of will and intestate succession, and retrospective legitimation by the marriage of the natural parents. The characterization. Characterization is the procedure to resolve a lawsuit involving a foreign law element. Once the foreign court has decided that it does have jurisdiction to hear the case, it then must characterize or classify the cause of action. Choice of law is procedural stage in the litigation of a case involving the conflict of law, when it is necessary to reconcile the difference between the law of different legal jurisdiction. The public policy. Public policy or other public is the body of fundamental principles that underpin the operation of legal system in each state. This addresses the social, moral, and economic value that tie a society together, value that vary in different culture and change over time. Example of public policy, like the most fundamental policy in the operation of any legal system is the ignorantia juris non excusat. The Latin for ignorance of the law is no excuse. It will completely undermine the enforcement of any law if the person potentially at fault was able to raise as a successful defense that he or she had not been aware of the particular law. The only exception to this rule excuse those of reduced capacity, whether as infant or through mental illness. For example, see the principle of do inspects, which raises an irrefutable presumption in criminal law that an infant is incapable of committing a crime. Jurisdiction. Jurisdiction is from the Latin jus juris meaning law and discere meaning to speak. Is the practical authority granted to a formally constituted legal body or to a political leader to deal with and make pronouncement on legal matter and by implication to administer justice within a defined responsibility. What issues are procedural? Issues identified as procedural include the following. 1. By initiating the action before the forum court, the plaintiff is asking for the grant of the local remedies. Number 2. The local law determines who can sue and be sued as party to the action. The case law in this question is not very consistent. Number 3. All questions of evidence to determine the admissibility and probative value of evidence and whether a witness is competent. Number 4. The statute of limitation is usually regarded as having public policy implication, particularly wherever foreign period and either very long or very short. Number 5. The lex fori determines whether a foreign judgment can be recognized and if so, how it will be enforced, what property belonging to the defendant might be taken to satisfy the judgment. Lex causi. In Latin language, lex and causi, cause for the law, is the law or law chosen by the forum court from among the relevant legal system to arrive at its judgment of an international or interjurisdictional case. The term refers to the usage of particular local law as the basis or cause for the ruling, which would itself become part reference legal canon. Lex fori. The Latin term lex fori literally means the law of the forum, and it is distinguished from the lex causa, which is the law the forum actually applied to resolve the particular case. The approach of lex fori. When a lawsuit is instituted and the court has expected that its jurisdiction, the party will normally expect territoriality, that each state is sovereign within its own border and the law of no other state or international body will apply extraterritorial or supranationally. If foreign law did apply, the state would be less than sovereign within its own border. However, as social mobility has increased and the internet encouraged people to trade across national boundaries, a need to recognize the relevance and importance of foreign law to dispute resolution has arisen. The forum shopping. Forum shopping is the informal name given to the practice adopted by some plaintiffs to get their legal case heard in the court, so most likely to provide a favorable judgment, or by some defendant who seek to have the case moved to a different court. Next is lis alibi pendens. If two courts were to hear the same dispute, it's possible that they might reach inconsistent decision. Lex domicili. The lex domicili is the Latin term for law of domicile. In the conflict of law, conflict is the branch of public law regulating a lawsuit involving a foreign law element where a difference in result will occur depending on which law are applied. Next is lex patriae. The term lex patriae is Latin for the law of nationality in the conflict of law, which is the system of the public applied to any lawsuit, where there is a choice to be made between several possibly relevant law and different result will be achieved depending on which law is selected. The lex patriae is a civil law. Choice of law rule in some states, the law of habitual residence is used to test the status and capacity and the parties to the case. Lexitus. The term lexitus refers to the law of the place in which property is situated for the purpose of the conflict of law. For example, property may be subject to tax pursuant to the law of the place of the property or by virtue of the domicile of its owner. Lex loci contractus. The lex loci contractus is the Latin term for law of the place where the contract is made. In the conflict of law, conflict is the branch in the public law regulating a lawsuit involving a foreign law element where a difference in result will occur depending on which law are applied. And lex loci delicti commissi. The lex loci delicti commissi is the Latin term for law of the place where the tort was committed in the conflict of law. Conflict is the branch of public law regulating all lawsuit involving a foreign law element where a difference in result will occur depending on which law are applied. Lex loci solutionis. The lex loci solutionis is the Latin term of law of the place where relevant performance occur in the conflict of law. Conflict is the branch of public law regulating a lawsuit involving a foreign law element where a difference in result will occur depending on which law are applied. Lex loci celebrationis. Lex loci celebrationis is the Latin term of law of the place where the marriage is celebrated. In the conflict of law, conflict is the branch of public law regulating a lawsuit involving a foreign law element where the difference in result will occur depending on which law are applied. Okay, next I want to talk about the material that I got, namely is lex patriae. Let's start from the definition. The term lex patriae is Latin for the law of nationality in the private international law, which is the system of public law applied to any lawsuit where there is a choice to be made between several possibly relevant law and a different result will be achieved depending on which law is selected. When a case comes before a court and all the main features of the case are local, the court will apply the lex fori, the prevailing municipal law, to decide the case, but if there are foreign elements to the case, the forum court may be obligated under the conflict of law system to consider, first, whether the forum court has jurisdiction to hear the case. Secondly, it must then characterize the issue, allocate the factual basis of the case to its relevant legal class, and 3. Then apply the choice of law rule to decide the lex causa, which law is to be applied. The lex patriae is a civil law choice of law rule. In some states, the law of habitual residence in use to test the status and capacity of the parties to the case. For example, suppose a person with a nationality in Denmark decide to take a round the world trip. It will be in announcement if this person's legal status and capacity change every time they enter a new state, that they might be considered an infant or an adult, married and free to marry, bankrupt and credit-worthy, and etc. Depending on the law of the place they happen to be, assuming there are no public policy issue, raised under relevant lex Patriae should apply to defend a major issue and produce an interim outcome, no matter what the case might be litigated. The common law state used a test a lex domicili, the law of domicili, to determine status and capacity, because the lex Patriae choice of law rule may select the law of country possible law might apply. A reference to the law of the United States is actually a reference to one of the US states. A supranational example of the selection process is contained in Article 19 of the Rome Convention. States with more than one legal system. 8. Where a state comprises several territorial units, each of which has its own rule of law in respect to the contractual obligation. Each territorial unit shall be considered as a country for the purpose of identifying the law applicable under the convention. B. A state within which different territorial areas have their own rule of law in respect of contractual obligation shall not be bound to apply this convention to conflict solely between the law of such unit. Here are some examples of cases that I will show and I determine lex Patriae. First case, between IPB versus American government. This case tells about IPB, Institut Pertanian Bogor, from Indonesia, and American government. IPB and American make an agreement to send 800 monkeys will be taken child, and they have a deal about price. And then IPB send the monkeys using airplane. When the position of the airplane is still in Switzerland, a monkey is dressed and released, giving birth to his child. Because the mother had been paralyzed and dead, the IPB veterinarian inject the monkey child to death because of pity. So, lex Patriae in this case, first IPB, lex Patriae is Indonesian law because IPB is one of university in Indonesia. From American government, lex Patriae is American law. Second case is Fargo case. Fargo was a Bavarian-born citizen and had German nationality, but he was a child of wedlock, illegitimate child. He then lived in France without changing his nationality. One day, he died in France and left his property without testament. Fargo's sibling for Germany came to France and want to take the inheritance in the form house property. So, lex Patriae in this case, first Fargo. Fargo, lex Patriae is Germany law because he is a Germany citizen. And Fargo's sibling is Germany law as a lex Patriae. Third case, between Bavarian Leger versus European Commission. Bavarian Leger was created to import bottled German beer for public house and bar in the UK. The product could not be sold easily because most of those establishments were bound by exclusive purchasing contract with certain breweries. Here it said that there is a other policy set by the European Commission in the case of import beer, and in this case the European Commission did not notify the Bavarian Leger, so that a Bavarian Leger was suspect. So lex Patriae in this case, Bavarian Leger, lex Patriae is Germany law, and European Commission as lex Patriae is Luxembourg law.